Hey everyone, I'm a second year law student of Maharashtra National Law University and my name is Samriddhi Bamidi. Today we'll be talking about two of the most important things which you might have heard if you happen to be a law student. Stare decisis, precedent, all these terms when we read, the first two things which come to our mind is obiter dicta and ratio decidendi. Now, to begin with understanding the concept of these terms, let us first understand the basic doctrine of precedent. What does precedent mean? What do we actually mean when we talk about things like stare decisis? Well, it simply means that when courts pass a judgment on any matter, or when a decision is passed by the judiciary regarding any case at hand, it is expected for the courts, for the judges in coming course to respect that particular decision and deviate from the decision only if the facts of the present case differ substantially. This respect, this adherence, and this legally binding nature which is given to the previous judgments passed ensures that the time of the courts is saved and the wisdom, the time, as well as the efforts that went into deciding a particular case at hand do not go in vain. This is essentially the doctrine of precedent. Now, we all know that apart from the material facts of any case, the facts of a decision or a judgment for that matter has two bases, the ratio decidendi and the other being obiter dicta. Now, if we discuss them one by one, ratio decidendi of a judgment can be defined as that reason or the principle of law that is formulated by the judge for the very purpose of deciding that particular case or problem before him. Okay, so whenever a judgment is passed or whenever a judge makes decision regarding any case, the final decision, that decision must have been arrived by thinking something, right? There must be some legitimate reason for deciding whatever has been decided. So, what is that reason? That principle of law, that reason behind deciding that particular judgment is what we call ratio decidendi. Now, there can be many reasons for deciding something social reasons, political reasons, and so on and so forth. But when we are talking about the legal arena, about a judgment being passed, we cannot really give importance to such social and political and other reasons. What we are only concerned with is the legal reason for deciding or arriving at a particular decision in a case, which is why we can synonymously use the term reason behind a judgment or the legal principle or the principle of law behind the judgment because we are only interested in the legal arena. We are only interested to find the legal reason behind arriving at a particular decision or judgment. And that, of course, is legally binding. Now, why is it legally binding on other courts? Because that principle of law has been established, and it is through that principle of law that that judgment attains significance, right? Now, when we talk about the other aspect, the obiter dicta, now what do we mean when we say obiter dicta? Well, it simply means the observations which are made by the judge just out of the way. Now, it is not really essential for the decision to be reached. It is a Latin phrase, actually, which simply means that whatever has been said just by the way, or say incidentally. The obiter dicta part of the judgment is not really concerned with the reason of the judgment, okay? Or you can say with the material facts of the judgment. It presumably is unnecessary, you can say, to the decision that has been arrived. It is merely a viewpoint, an opinion, or an expression or sentiment of that particular judge. It has no binding effect because it is not really related to that case. It is simply an expression or opinion that the judge arrives at, by the way, just incidentally out of the case. It can be unrelated to the case. Okay? And it has no principle of law involved in it. Okay? Which is why it does not have any binding effect. Now, I'll give you an example of this to make things really clear. The Supreme Court, the apex court, in the case of Arun Kumar Agarwal versus State of Madhya Pradesh, held that the obiter dicta part of the judgment is a mere remark or observation made by the court. Okay, it is not a legal principle, it is not a legitimate reason, it is mere a remark or a sentiment or an expression, whatever you may call, while deciding the actual issue before it. Okay, and the court specifically held that such casual statements or observation which is not essential or which are not pertinent enough to decide the issue at hand did not form part of the judgment of the court and does not contain any authoritative value. Now, by this term used by the court, authoritative value, it throws light on the binding effect or the binding status of this obiter dicta part, which I have already cleared. It is not binding at all. Now, in the case of Madhav Rao, Jivaji Rao Scindia versus Union of India, which is yet another case, a case which took place in 1971, long ago, the apex court, while stating about the relevancy of obiter dicta, again held that it becomes really difficult and it is presumably very hard to regard a mere clause, expression, or word occurring in a judgment as a part and parcel of the law or the principle of law or the judgment, given the fact that it is not answering any direct question of law or it is not related particularly to the facts or to the case in general at hand. So, since it is very ambiguous and it is very vague, one cannot attach binding value to obiter dicta. Thus, it can be well concluded by just simply mentioning that obiter dictum is an opinion which is not really necessary to a judgment. It is an observation, okay, which is made by the judge in the course of the case, but it is not really essential or necessary to the decision and therefore it has no binding effect. It is therefore also called remark by the way. That is what people generally call it, remark by the way, something which comes out just incidentally out of nowhere. But again, I would like to remind here that it is the ratio decidendi which has the binding effect, and it is the ratio decidendi which has the precedent value for any case or judgment. That's all for today. Bye bye.